presenter is Nikola Dožić from Montenegro.
Hello.
Hello, Nikola. You can start when you are ready. Please share your screen with us.
Okay.
Okay. Full screen,
I
please.
hope, yeah.
Okay. That's it. You can start.
Okay, thank you. For my presentation, we had the idea of sports competition and free movement of workers in the EU because of the famous ruling by the European Court of Justice in the case of Bosman. So first, there are a couple of questions that we have to answer. What was the influence of the free movement of the workers, and what was the historical the organization of sport competitions in Europe before? Did, again, UEFA had a specific privileged position in the decade before these crucial decisions, and what were the relevant circumstances in the Bosman case, and what were the consequences of this decision? Again, the implementation of Article 45 of the Treaty of European Union on European sports organizations. This was actually the emergence of the European sports law. So now we have the first couple of judgments of the European Court of Justice in the case of Raven Koch versus Union Cyclist International in '74, and the second case was Donna from Italy in 1976. Again, after these rulings, there were the negotiations of the European Commission with the UEFA regarding the nationality quotas and transfer system of players, and the famous gentleman agreement between the UEFA and European Commission in '91 about the 3+2 rule that were introduced by UEFA in this case. Then there was this famous decision of the Bosman case, which were the versatile, and they were the subject of many different analyses, not only because it has for the first time established the prohibition of restrictions of free movement of workers, which also applies to the activities of private law entities of non-discriminatory nature, but primarily because of the effects of the judgment on the organization of the key club contest in football and football market itself. So what were the facts of the case? Actually, the factual legal situation was rather complex regarding to existing system of football transfers in early 90s, which has caused the failed transfer of Belgian football player Jean-Marc Bosman from his Belgian club to a French club in Dunkirk. The actual factual and legal situations in the disputes brought before the Belgian Football Association and Bosman, the Belgian football club Legion Bosman, and Bosman and Union of the European Football Associations was subject of many papers, but in legal contest, the most important and famous was the proceedings before the European Court of Justice. Again, one of the major questions was the question of whether the football club can actually ask for the compensation to the players before hiring a new player, and is this a non-discriminatory measure that was unacceptable? So in the proceedings, two questions were brought by the European Court of Justice for preliminary ruling. First question, again, you can see on the slide, was whether the football club can actually require and receive payments of sum of money upon the engagement of the player after his contract was expired. And the second question was, again, regarding the International Sporting Association's rules regarding the access of foreign players outside of the European community and inside the European community. So even in the question itself, we can distinguish the difference between the direct and indirect discrimination. The case of direct discrimination is evident in the second question, in the rule that has actually survived because of the gentleman's agreement between UEFA and European Commission on the basis that the European football market, which UEFA actually managed, would be an exception to the rules of the founding treaties on freedom of movement of workers as a result of the informal gentleman's agreement and the 3+2 rule. It was not surprising then that the Court of Justice had taken the view that the answer to the second question must be the affirmative one. So in answering the first question, actually they drew an analogy between the freedom of establishment and freedom of movement of workers. The first question actually is more interesting, and the question of the existence of the right to receive payment of the sum of money upon the engagement of one of its players who has come to the end of the contract by a new employing club. It could be justified to conclude that this is an impermissible restriction, and noting that it could be justified only if the activity achieves legitimate objectives from the point of view of founding treaties, which however justify the overriding reasons of general interest. Discriminatory measures that were actually discovered in this case is the standard of freedom of movement of workers established in this case. It was actually the first case regarding, and the most prominent case in the context of direct horizontal effect of freedom of movement of workers. But direct effect was actually established in some previous decisions, but this was again prohibition of discrimination on the grounds of the nationality of workers. And again, we have some new, again, rules that were brought by this decision. Justice actually never explicitly stated that the disputed rules were an obstacle from a non-discriminatory nature. Nevertheless, it is clear that these rules are actually this kind of restrictions. It may be not the most famous distinction of the Bozeman case among most other interesting ones that he actually stated in the area of football, but again, one of the more significant one in the area of law itself, because it was argued about the provisions of the founding treaties had on the fundamental freedoms of the internal market in the entirety of the EU, not regarding only the sport competitions. And again, court actually, while arguing this case, was again arguing that the standards that were actually established in the previous cases in Valrave and Koch, which was actually one of the first cases regarding the sport competition in Europe, and the rules established by the National Cyclist Association regarding the rule that the driver or the pacemaker of the cyclist in front of him had to be of the same nationality. So these were some of the restrictions that were actually discovered in this case, and the restrictions were prohibited with regard to exercise of the freedom of movement of workers. And it applies not only to the activities of public bodies, but also to the rules of different nature aimed at the collective regulation of employment and provision of services. This is actually really important because the direct effect of the measures actually established previously was generally accepted, but this was one of the better sides of the Bozeman ruling, because they actually stated that not only the direct prohibition applies, but also to all the other bodies that actually regulate this area of employment, not only the public bodies that were actually involved, like in the horizontal effect. Application of the prohibition of the non-discriminatory restrictions widen the private law entities to the collective regulated employment and services. So actually every employer collectively regulated employment and services had to obey by the rules of the European Union. And for the conclusion, this was one of the most famous cases. Maybe Bozeman actually became more famous as a case through the European Court of Justice than as a football player. But again, This case had a large effect to the other judgments of the court that followed regarding the Lettonen case and Olympic Leonisis case, maybe more famous in the non-lawyer community, but again, they confirmed the prohibition of non-discriminatory restrictions established in this case of Bosman and problematized the rules of international and national sports association in compliance with the provision of the founding treaties guaranteeing the freedom of movement of workers in the internal market. So in the case of Olympic Leonisis, it was the contract that young football player had again concluded not with his first club, but with Manchester club, but it was again ruled in 2010 and reaffirmed the application of the principles of the horizontal direct effect of the fundamental freedoms, and that they also apply in the area of sport and sport competitions that were organized in the European Union. Again, the decision in this case upheld the standards of non-discriminatory restrictions, and in short, these were the facts of these cases. So I'm open to any questions.
Thank you, Mr. Nikola. It was interesting presentation. Are there any questions? I can't see any questions, and I have one question for you related to Bosman rule and football.
Yeah.
Do you think that Bosman rule enabled well-studying clubs to bring around 20 or 24 foreign players and thus disable smaller clubs?
Yeah, actually, yes, but this was actually the great rule of the European Court of Justice in this case, because they stated because the footballers actually are the employees. So why should they have to be limited of choice by the club that they have to play, or they have to obey by the rules regarding the rules by UEFA? So actually, it is evident nowadays that the larger clubs actually which have great sums of money can actually hire the players they want and to rule the sports scene. No, I'm not a football fan, so.
Yes, yes. Do you think that is good for European football to have all this power in just few European clubs?
I don't know. That's maybe something more outside the legal area, but inside the legal area, it was argued that the fundamental freedoms of movement of workers, one of the 4 founding principles of the European Union, must be obeyed by all employers. So this is why this was the case, and why the court decided this way.
Okay, thank you, Nikola. Are there any questions?